There's Robin and Val. All right, let me pull them both over.
Okay.
Robin and Val and Val. Okay.
So I think we're all set. It's 7:01, so let me begin. Good evening, everyone. Welcome to the Planning Board meeting of April 6th. This is a meeting tonight where we'll have some site plan reviews, but also a public hearing. So before I get started, following the guidance issued by the Commonwealth in March of 2023, regarding the open meeting law, the public meeting will be held remotely. Any individuals wishing to participate may do so utilizing via Zoom and by clicking on the link that's included on the agenda on the Town of Dover website under calendar. So with that, I'm going to do a roll call vote. Katie Williams,
Here.
Jody Shu,
Here.
Val Lynn.
Here.
I'm here, and Eric Aberjali.
Here.
Great, thank you very much. We also have Christine Brown, our assistant, and our Board of Selectmen liaison, Robin Hunter. As usual, we start our meetings with any citizen comments. So for any citizens, and I do see 9 panelists now that are here tonight and would like to provide a comment on something that is not on tonight's agenda, please raise your hand and we will bring you over. I see that Justine has her hand raised.
Yep. You're unmuted, Justine.
Yeah, I don't understand the rules, Carol. I think if you want citizen input, you should actually get citizen input from things that are on the agenda. So I don't get it. Could you please explain why we're not allowed to talk about things on the agenda?
Well, you will be able to talk about things on the agenda when we get to that agenda item. So
Fine.
this is
Thank
just
you.
okay.
Thank you. It wasn't clear on the town calendar.
Okay,
If you could clarify that, okay?
okay.
Thank you.
Mhm. Anybody else? I don't see any hands raised. Anybody see any hands raised? Melissa, you see anybody? I don't see anybody.
I do not, Carol.
Okay, if that's the case, then we're going to go to the first item on the agenda, which is the public hearing. So I am going to take a vote to open up the public hearing. This is on public hearing for the annual town meeting Article 18 and annual town meeting Article 19. Val? We're taking a vote to open.
You're voting. Would you like to open the meeting?
Carol, we need a second on the motion if you made
I second the motion.
Great,
Thank you.
Val?
Yes.
Jody?
Yes.
Katie?
Yes.
And of course, yes for Carol. So the public hearing is now open, and I am going to turn it over to Melissa to explain the format of the public hearing and how we're going to proceed.
Thank you, Carol. Good evening, members of the board and those members and residents of Dover here with us this evening. As Carol had mentioned, we are here for our public hearing for our annual town meeting articles. And before we get into the language and the memo that I have prepared for review tonight, I'd just like to cover a couple procedural items. And noting for the record that the amendments were filed with the Board of Selectmen on March 2nd of 2026. They were transmitted back to the planning board on March 6th. We made public notification in the Hometown Weekly Dover Sherborne edition on March 19th and also March 26th. We also posted the advertisement and legal notice in Town Hall on March 12th. And we mailed legal notices to the abutting communities and also the entities specified in Massachusetts General Laws, Chapter 48, Section 5, which relates to zoning amendments. So we have legally fulfilled all of the noticing requirements associated with this particular matter this evening. What I'm going to do now is pull up a memo that I have prepared for review this evening. This is available on the town website on our dedicated page for the 2026 annual town meeting articles. You can also find on that page the text as it appears currently in the bylaw, some red line versions, and some clean copies. To save everyone the torture of going back and forth between a whole bunch of documents this evening, I have prepared a memorandum so that we're able to cover this all, scroll up and down as needed through the text, and answer any questions from the board members and public. Important to note, the first section of the report, I did receive some questions from members in the community. These are all included in this report. There was 7 questions. Carol, would you like me to run through these and the responses, or would you like me to summarize?
I think what I'd like to do is to start with the any questions that were relative to Article 18, handle those, and then we can go through the questions from the public on Article 19 when we get to Article 19.
Okay, let me just double check. I don't think any was specifically related to the ADU. I'm just running through just to make sure, not misrepresent. And that is correct. The questions from the public were related to Article 19 site plan review.
Right. So since the first item on the public hearing agenda is the ADU amendment, even though it's section 2 of the memo, why don't we jump to the ADU?
Okay,
to get
of
that?
course.
Yep.
Just bear with me as I scroll down here. Okay. So just a little bit of background. As folks know, there was some legislative changes in the Housing Choice Act some years ago. And one of those was making accessory dwelling units a protected use under Section 40A 3 in the state law. So what that means is local municipalities, including Dover, need to amend any provisions that were in place in order to allow for accessory dwelling units by right. The planning board undertook zoning amendments last year that were passed at the annual town meeting in May. Subsequently to that action locally, they were submitted to the Attorney General, and the Attorney General had some comments relative to our language, things that we needed to correct. The first thing that stood out in the memo from the AG was we were using the term single family dwelling so that our ADUs were accompanying, quote, a single family dwelling. The way the guidelines are written in the statute, it's the preferred language by the state is the principal dwelling, noting that if you have a 2-family or a 3-family on the property, you are still able to take advantage of the ADU provisions. So this isn't primarily for single families, while that is predominantly what we have here in Dover. That language didn't jive with the Attorney General. So we've gone through, clean this up, and I will go through once again to make sure that everywhere that it said single, it now says principal. And there was one spot in here where I believe it said residence, and we've switched that over. As we say here in the additional standards. The other thing that stood out in the memorandum from the Attorney General was they didn't like the way that we calculated the half of the primary dwelling unit or up to 900 square feet, whichever is smaller. So what we did, just to simplify things, we went to the regulations, we pulled out the definition of gross floor area. Hence, in this section, you see gross floor area for the purposes of this section, and pull the definition right from the ADU regulations. And then the third thing that we did was we also inserted a definition for principal dwelling. So the terms that are new in here are now defined, and anything that needs to mirror the ADU regulations has also been amended. And that's essentially, it's more of a housekeeping. It doesn't change what you can do, how you would do an ADU, the process for an ADU, or where they can be located. All of the requirements related to if you have more than one, you need a special permit, all that stuff is still in place. So nothing related to process, just cleaning up the language so the state is happy. Thank you.
Thank you, Melissa. Do we have any questions from planning board members? Jody?
I don't actually have a question. I just wanted to mention so that it's on the record. And Carol, you and I didn't talk about this, but I think it's a good thing to mention in this meeting. Dover has really been a leader when it comes to ADUs in the state. And we had a bylaw that allowed for ADUs before the state required this. And we've been literally working on ADUs for I mean, I think this is our fourth or fifth year in a row. And so we had something that was passed like in 1986. Dover's really been at the forefront of this statewide. And we've been working really hard to clarify and come into compliance with the state and to be super clear with residents what this is all about. So I appreciate, Melissa, that hard work responding to the state's feedback. And I also just want to commend the planning board for having been ahead of this and having worked really, really hard to create an alternative for homeowners who were interested in this housing option. I think we've done a really good job here on the planning board being ahead of this. And I think your changes are perfect.
Thank you.
Thank you, Jody, our Miss ADU.
Well, I just happen to be a part of it, but I think that Dover's unusually ahead of this ball, and I think that's a real testament, and it certainly precedes me to forward thinking on this issue for Dover residents.
No, it's a good point. Thank you. And in fact, I think we had 5 ADUs last year, so they're ramping up, no doubt. Any other comments or questions by planning board members? If not, are there any comments or questions from other attendees? If so, please raise your hand. I see no one raising their hand. So seeing none, we will then move on to
Carol, I'm raising my hand.
sorry. Justine?
Yeah, 2 questions. How many ADUs do we have total in the town now? And secondly, please clarify for people who may not know how we protect our water and septic systems by having ADUs, please.
Okay, well, I don't have the total number that we have in town, and we can get that, and thank you for that. It would be a good thing to add to the town meeting. As far as protecting water and septic, as a residence, the ADUs fall under the same regulations and the same review process for as a single family for the Board of Health, Conservation Commission, and so forth.
So there has to be adequate, in other words, water from wells or aquarium to supply both the ADU as well as the principal residence, correct?
Yes, and that's done through the Board of Health.
Right, and ditto septic system.
Yeah.
correct?
Yes, yep.
Yes,
absolutely.
thank you.
Okay. Any other questions from attendees? Seeing none, we will now move to Article 19 of the annual town meeting, which is site plan review. And I'll turn this back to Melissa.
You can just bear with me. I changed my screen view and now I just need to get it back. Oh boy. All right, let me do this. Let me just share it again. I wanted to see the speakers and fortunately lost other people. Okay, there we go. All right. So do you want to go back to the questions, Carol, or do you want to get right into the text?
I'd like you to go through the questions sort of in a summary way.
Okay.
We'll give people time to quickly scan them as well.
Yeah. So, question number 1, and then further down, one of the other questions from another person who had reached out, related to extensions. So as we know, the planning board has 30 days to act on a, well, now it's called preliminary site plan review. We'll get into that a little bit more, and then 60 days on a full site plan review. Time to time, applicants may not be ready and they need extensions, and the planning board from time to time needs additional information and may not be ready to vote on a particular application. And the questions were related around, are they mutual? Are they in writing? And sometimes it will be in writing if it's before a meeting and someone knows they're not going to be ready. They would submit something and ask that the matter be continued and that the deadline to act be extended. That would be presented to the board at the next meeting. There's also times when we're having a meeting, whether it's a partial site plan review or a full site plan review, and it becomes evident during the meeting that something has come up that has yet to be resolved. And there's discussion about a continuance. And in those particular cases, the planning board will vote the continuance. The most important thing is that something gets stamped in with the town clerk in advance of that clock lapsing, that documents there has been an extension granted and that is on file. As the board members know, those the public that here with us that may or may not know, the town clerk is sort of the keeper of, quote, the clock on applications related to land use. The second question was questioning what we would consider detrimental impact. And the response is detriment isn't necessarily one thing when discussing impacts from a use, structure, or development, but it can be a combination of attributes, occurrences, and results of how they are received by the abutting properties. And we've listed some examples here. I'll read a few of those. C, one of the examples we gave is the constant odor from excessive storage of horse manure or garbage. So if somebody is putting up a horse facility next to you or in your neighborhood and they're not properly taking care of the manure, well, the smell of that to some folks could create a detriment, and it could be something that frankly drives them crazy. Something else that could be considered a detriment is the emptying of a commercial dumpster during overnight hours, the sound of banging on the ground and backup alarms. So I know we have a fairly small business area in town, but activity like that associated with a particular use that occurring every couple nights at 4 o'clock in the morning, that's something that could rise to a detriment. Being woken up every night is something that could lead to being harmful if you're not getting enough sleep. And as you can see here on the screen, some other examples. And again, the memo is available on the town website for a deeper dive. The third question is an abutter being able to see a new structure a detrimental impact? And no, the actual visual on its own merit is not a detriment. The fourth question asks, why have you reduced the validity of approved site plan from 3 years to 2 years? So the bylaw is silent on site plan review. So is state law. Our bylaw says that you have 2 years to exercise a special permit. There is nothing in our bylaw about 3 years. State law does in fact say that you have 3 years to act on a special permit. Where we have the 2 years currently in our bylaw that has a lot of sort of inconsistencies, we're not looking to add to those. So we're proposing a 2-year time to exercise these, which mirrors our special permit. Once we get into future revisions, changing those to 3 years is something that I would be discussing with the board, but we have not advertised the specific section where it is for 2 years for the special permit. So we want to try to keep the sections that we do have control over here locally consistent. Could you define what exercise means to toll the expiration of a permit? And typically it's if there's a structure, it's the building permit. If this was something that didn't require a building permit, let's say it was let's see, wouldn't require a building permit. Maybe a sports court, which we're going to be talking about a little bit in the future. Fencing, mobilizing, starting to prep the site is getting, ready to do what you have permission to do, and that would be deemed exercise. Question number 6. In paragraph F2O, you speak of landscape screening and buffering. What factors would be considered to require landscape screening or buffering? Can you give some examples? So the determination of whether or not screening or buffering would be required would be based on how the proposed use indoor building would, 1, conflict with or impact the visual benefit of natural vegetation and tree cover on the property and abutting properties in the public way in some cases, and 2, conflict with or impact the other benefits, noise, privacy provided by screening and buffering, and how that serves to further promote and protect the vegetated character and the zoning of a particular property. So different instances, it's very contextual. What are you going to do on the property? What do you want to do? Do you need to remove trees? What use is going to be happening here? Is there noise associated with that? Is there lighting associated with that? So very site specific, very contextual in being evaluated against the criteria in the zoning bylaw. The next question also talks about or asks about timeframes, and then also asks about the town clerk stamp and how that happens on applications. So as most folks know, we're now on the OpenGov online platform. An application is submitted. We get a message in the platform. I also get an email directly to my inbox if I don't have OpenGov open at that specific time. We review the application, the required materials to make sure that everything has been submitted that is required. And we do a very quick look at the plans and the materials. We don't do a full review of the plan, but we make sure the required documents have been submitted. The application has been signed by an authorized entity. And then we prompt the fee in the system. The applicant will pay the fee. And then electronically, I transmit that application to the town clerk, at which time they go in and make an electronic stamp on the application. So fairly quick turnaround. And then the last question was about some language in the use table. In the category said accessory use not detrimental to a residential neighborhood. In talking with town council, I'm looking at this second part, not detrimental to a residential neighborhood. And that's really kind of putting a sort of a question on the use. And it's also saying residential neighborhood. If you look at the use table in the line item, accessory use is not just for residential districts. It's for open space districts, business districts. And therefore this language, frankly, doesn't apply because this is a category for the entire town and every use district that we have here in Dover. So that was the questions that we received to the board members and the public and the responses that we put together. I don't know if we want to do any more discussion around that, Carol, or if we want to get in.
I would just like to take the opportunity to thank those citizens who took a look and who have been working with Melissa. Your input is always important and always helpful. We try to get to something to town meeting that reflects the will of the people, if you will. And so it's nice to know the will, and it's nice to know the questions. So thank you to those who have been in contact with Melissa, both through emails as well as conversations. And I think now we can go on to the actual bylaw.
Okay. I just want to start out by saying this is also currently under legal review. I did speak to our counsel today. They are wordsmithing. There's a few things in here. I used building/structure. They like building and structure. So cleaning things up. There are no glaring concerns as far as the intent in the language. Again, just kind of cleaning things up. Hope to have their comments in the next few days. So the first section that deals with site plan review was the definitions. 185-5 is the section of the bylaw. And I had put in a definition for partial and site plan review. And our council said that we don't need to have a definition in there for a process. So that will actually be removed. What they did ask me to put in was to update the definition for accessory dwelling unit. Again, you can see the text in blue, just taking out single family and putting in principal dwelling. So again, now the definition and the section will be uniform and consistent. The basic requirements section is the section of the bylaw that now says P and A and not required, and frankly, is not the easiest thing to read. And what I have proposed here is to put some more basic lettering in. Y means yes everywhere, N means no everywhere. Then we get into the specific applications, and each box is coded. So you'll be able to go to any zoning district in any use and follow those two on your X and Y, and you will know exactly what type of permitting you need and what board you need to get it from, whether it's site plan review and a special permit. Maybe you're in the official open space zone, so now you need to loop in the Board of Selectmen as well. Very clear and distinct in a box what you need to do and what board is going to be issuing that specific permit. How those transcribed and what they mean for the table, and the only thing I've included in the report are the things that changed from maybe an X to a different coding or something like that. Something that went from an X to an N is not shown here because there are no significant changes. It's just using the new terminology. So the first thing that we have here in the bylaw, and I put some notes so everybody can, follow along it. What is she thinking and what does she mean? So the first one is church or religious purposes. And that is an exempt use and typically allowed in all zoning districts. So what we've done is we've cleaned that up and taken the X and put in the full site plan review. So you can see across the table, all church uses, any district, anywhere in Dover is required for a full site plan review. Same thing applies to the educational use. We have changed the X to the full site plan review. Municipal use, in that particular category, let me see, that one was, so the municipal use in the official district, before it was allowed, and it was allowed by special permit. And the question now becomes, do we want a special permit for municipal uses in the official or open space district? Keeping in mind that the official and open space district, if you look that district up in the bylaw, it's essentially 4 town uses and recreation uses and things of that nature. So if that's what the district is for, it's really kind of a policy question of why are we requiring a special permit for pretty much the use that's really kind of created for. So I've put it in as either partial or full site plan review because we are in the O's district, the Board of Selectmen are involved. So just looking for a little input from the planning board. in that particular scenario. As you can see in all the other districts, residential, obviously, municipal use would need a higher level of review in those specific districts, in a discretionary level of review. Again, making the distinction that those districts are not specifically called out for town uses. So I don't know if you want to pause, Carol, and have some discussion on that
Yes.
specific. Yep.
Yep, I think we should pause every time we have a decision and a
Yep.
recommendation to make to you. So this is really the first substantive question that we have. And before I open it up, I will note just to remind folks about this, that we've really only had recently 2 site plan reviews that we've done in official district. One was for the community center, and then more recently for the fuel depot at the highway garage.
Mhm.
So with that, I will open it up to thoughts and comments by planning board members.
Carol, I have a question. When there was a proposal for lighting at Carroll, I think Carroll Park, was that something that the planning board got involved in for a site plan review? That was before I was on the board, and I think I had just moved into town.
I don't know. Melissa, would that require, under our current bylaws, would that require a site plan review by planning board if Park and Rec wanted to put the lighting on the tennis courts?
No, unless there was some decision from the past that restricted that or required that to be looked at. Lighting on its own does not trigger planning board approval.
What about if it's a turf field?
We would have to look, no, I mean, we'd have to look at the, we have further down in the text, we have change of use, expansion of use. There's sort of measures to quantify if you're an existing use, when you would come back to the planning board. So that I lighting on it, again, lighting on its own, I don't believe, and we don't have a lighting bylaw, so there really wouldn't be any, like something specifically separate out of site plan review that regulates lighting in the bylaw or makes a connection to site plan review. We don't have those sections.
Huh. That's interesting. It's a great question, Val, though, because thinking back to the high school field getting lit, I wonder, I think that was before my time. I wonder how that occurred.
Yeah.
I will note that in a conversation on these bylaws, Melissa is keeping, well, from day one, when she joined us in July, she's keeping a list of bylaw issues that she wanted to discuss over time.
Yeah, that's great.
And one of the top ones is the fact that we do not have a lighting bylaw. We don't have
Robin, do you have something you could share with us about the high school turf field, just as a comp? How that went down?
So I remember there was a significant amount of discussion with the abutters there,
Right.
because there was actually a negotiation because the turf field now presented an opportunity for night games, and there
Right.
was actually a negotiation with the abutters as to how many nights the lights could be on and what time. I could touch base with Dawn and see if she has something documented, but that was a huge deal.
Right.
Was that a community discussion and public relations type thing, or does anybody remember whether that was a specific bylaw that was raised?
I don't know, and I wonder, because if it was at the region, it was different because it's a little funky because they're sort of their own municipality.
Right.
But let me see if Dawn knows. But Carol, I want to say there was a written agreement and now they went to LED lighting, which is less intrusive with the new turf field. Let me send Dawn an email and ask her if she remembers. But I remember spending a significant amount of time with the boosters because it was a big issue.
It was a big deal, right? I remember. I feel like I might have been around for that, not on the planning board, but for sure, yeah.
Right, and people were really upset
Yep.
about the lights and how
This
often
just
they
happened in Wellesley, for example. Their football field over there by the Whole Foods, there was like multiple years of discussion about lighting of that. And I wonder, not that, it's the same, but just curious.
Right, and that was the big, so now I remember that being a big deal because they wanted to do Friday night football under the
Yeah.
lights,
Yeah.
and they negotiated the number of Friday night games that they have. Yeah.
Yeah. Okay.
Well, another reason to make sure that, maybe add to, for next year, that we have that we get a bylaw that puts together, that talks about lighting in general and dark skies specifically, as well.
Mm.
We have a couple, so before I get to the attendees, are there any other questions or comments from the board members? Okay, Melissa, I see 2 hands up.
Correct. We have Tom here. Let me unmute you. Should be all set to speak, Mr. Here.
Okay, thanks. Actually, I had a question on your question and answer section. Maybe I didn't raise my hand fast enough on your response to the first question about extensions. It's unclear to me, and from your response to the question, to make it explicit that the applicant must also agree to an extension, not just a board vote to extend it. I think that's what's intended, but neither is when your response didn't say that. It said the board would vote during a meeting, for example, and it would be extended based on the board votes only. And it really needs to include the approval and acquiescence of the applicant.
Yes, that's correct, Mr. Here. The full, I didn't read my entire response, just trying to be a little bit efficient here. But it is, the third line of my response says all extensions must be mutually agreed to by both town planner or planning board and the applicant.
Okay.
And
Thanks.
that's kind of that's how all extensions work. Did you have any other questions, Mr. Here?
No, that was it.
Okay.
Thanks.
Would you like me to go to the next speaker, Carol?
Oh, yes, please.
We have Mr. Fryer. You have been unmuted.
Hello, good evening, everybody. Can you hear me?
Yes, you can, Jonathan.
Oh, thank you. First, I'd like to thank Melissa for putting up with all of my questions and meeting with me. And I congratulate her on tackling this problem. I do, however, think there's a lot still to be done on this. And if I could go to my questions first, and I'll just follow up on Mr. Here's question. The language in the bylaw you put in there, it really doesn't read to me that an extension by request by the planning board has to be agreed to by the applicant. Could that be cleaned up a little bit in the bylaw?
Sure. I can go back and take, it appears in 2 separate sections. It's extensions not only on the partial, but also the full. So extension language, clarify. Extension language, clarify. I apologize. I'm trying to take notes and
No, that's
follow
okay.
along here. Let me just see exactly.
For the exact,
Yes, so I'm gonna, let's see. The planning board shall act on a partial site plan review application within 30 days following the town clerk stamp on a complete application. Failure of the planning board to act on a site plan review application within 30 days shall be considered constructive approval. The applicant and the planning board have the right to request an extension of time to act. Said extension shall be made in writing to the planning board. Said extension shall be received and acted on. So do you want like the mutually agreed to language that I put in the response? Would that be clarifying?
Yeah, because it just sounds like now the board can request one.
Let me just make a note here. Mutual.
Like of the town. No.
Okay.
Okay. My question number 2 on detrimental impacts. Your first example is noise output. We don't have a noise bylaw. So how would you judge whether noise is detrimental?
I think that would have to be based on field observances, what's occurring, how often it's occurring. These would be things that would come up from abutter complaints. The bylaw, as the chair had mentioned, Mr. Fryer, is going to be a work in progress. And one of the first observances, when coming to Dover was, this is what we use the most, and we really need to clean this up. There will be multiple amendments coming forward. Hopefully we're successful getting the money for our master plan, and we can really get into some really deep discussions with the community and really try to gauge concerns, things that have been, bothering people, things that people like, so that we can have a bylaw that reflects what the residents of Dover would like to see in their community.
Okay, but that doesn't help us today. Is there a standard?
For noise?
Yeah.
We just have the construction section in the general bylaw, but I don't believe it includes decibels.
So really, noise wouldn't be something within the planning board's purview.
It would, well, I think depending on the use and the context and reviewing the criteria,
An example. I work better with examples.
An example of the noise?
Yeah, that you would find detrimental and how it would be determined.
I've given this, so for example, I give the example of, let's say we're in a full site plan review context for, we'll say the Dunkin' Donuts.
Okay, let's just, could I just stick with the residential accessory uses? I have the commercial ones, I think are really pretty justified. But when we get to the accessory uses, I'm really concerned that there's so much overreaching and such vagueness in this that there's no standards.
With all due respect, Mr. Fryer, this was a question that you have asked, and we've tried to eliminate things that were very vague from the criteria. We will address that criteria a little future on in the discussion, but in a residential setting, without seeing the combination of activity and what is being proposed, I don't know if I could pinpoint that. This is the first example that stands out, because I've had personal experience with courts in residential neighborhoods causing disruption.
Oh, so I agree with you. I agree with you 100%. I'm just saying we have no standards. So who makes that decision? The planning board?
If we're in a review context, it would be questions about what's going on, what type of activity, what are the hours of the activity. If it's something that is permitted and it's post that, it would be the building inspector. If there's some type of request for enforcement, or if there's a complaint being made.
Okay, but so that's enforcement. That's after the fact. I'm saying you're in a hearing for a exterior sports court. What's your criteria to put any restraints on their noise?
Currently, we don't have a noise bylaw. Again, I think it would be best practice, and the planning board would be evaluating that under the site plan review criteria.
What other
and
criteria?
anything that correlates. Well, we do have site plan review criteria.
Yeah, what are they to noise?
Let me scroll down.
Jonathan, this is Carol.
Yeah.
I would say at this point that I would have to quote a Supreme Court justice when he was talking about pornography and said, "I know it when I see it." And at this point in time, I would say that we have planning board members of 5 relatively attuned and intelligent folks who might recognize a noise problem when they see a use. And that's basically what we have at this point in time. And as we've said before, we know that as we go through these bylaws, you start peeling the onion and there's so much that has to be looked at. And I appreciate the fact that you brought this up because it's always best to have some kind of quantitative versus qualitative. And we'll work on that.
Well, why don't we work on it before you ask to amend the bylaw?
With all due respect, Jonathan, we're not tackling noise in this right. This is to clean up a very used process to create clarity and to highlight things that could improve the process and make the process very clear so that when somebody picks up the bylaw, they know what they have to do, how long it's going to take, and where they need to go. And that is the goal here. This is not a goal.
I do understand your goal, and I'm sympathetic with it. But if an applicant picks up the process and wants to know, what do I do about noise? They don't know until your board meets, a neighbor screams, and you guys put all conditions on it. Right now, the building inspector has authority to go in and shut down noise, or the police. I'm not sure why the planning board should be getting into this.
And I was answering a question that you asked.
Yep. All right.
I think, Jonathan,
Let's
if you
move on to the next one.
Yes, we will. Thank you.
All right. Let's see. Number 3, a new structure, whether a visual of the structure is a detrimental impact. And you say, no, it's not. But then when you go down to the answer to number 6, you say screening could be an impact of the visual benefit of natural vegetation or tree cover. So,
yeah, well, some people remove vegetation, and additional vegetation needs to be provided depending on what they're doing.
So why?
Depending on what they're doing. And Jonathan, I can't answer every question of every application that we're going to get. They're all contextual. Where's the property? What's abutting it? And what does somebody want to do? They're not.
You have
if it
no
was a,
standards
excuse
for any
me.
of this.
Excuse me for a moment. Jonathan, you have been
Yeah.
in communication with Melissa for quite some time. You and she have spent some hours or, communicating. This memo was sent to you before tonight.
Yeah.
I find your questions relatively combative at this point, and I think the best thing to do, since it's the first of 2 hearings, is for you to meet with Melissa after tonight and before next Monday's second public hearing on this to get your questions better answered. And at this point, I'd like to move on.
All right. Thank you, Carol.
Where were we?
So let's see.
We have some other hands up.
Justine?
Yeah. Just observation. I
What?
do think noise is at least from the 50 years I've lived in Dover, is an important issue that actually Jonathan is raising. It might be helpful if you, as the planning board, could communicate, if you haven't done already, with the police department as to what sort of enforcement, if any, whether it be rules or regulations that the average homeowner like myself could avail themselves of if indeed the pickleball court people continue to, I don't have, by the way, any pickleball court people next to me, but if they proceeded to play pickleball until 10 at night and I was trying to get to sleep, I think the standard around here is people want privacy and quiet. And somehow, and most of the time in my neighborhood, we actually have that. And I think barking dogs, frankly, is the thing that has most distressed me versus parties that lasted way into the night. But I do think noise, I will actually back Jonathan on this one, is an issue for that a lot of us are concerned about. I don't have any solutions, but I just raise that as a concern.
So Justine, we all agree that noise is an issue, okay? And hopefully by next year, we will have addressed the next layer of issues with these Dover bylaws that haven't been looked at for 30 or 40 years. Just like at the last town meeting, we promised that we would start taking a look at the site plan review, and that's what we're doing with our first pass. And we will probably be back every year for quite some time with additional changes to it. And I don't think anybody disagrees that noise is an issue. We had this discussion, actually, and I know Justine, you spoke about it as well, when the planning board was working on the construction hours
Right.
bylaw last year. And we made it clear that addressing the construction hours was our first pass at noise because it's something that the building inspector had asked us to look into, knowing that we had other aspects of noise that we had to look into.
Yeah, I guess I just would second Jonathan's request that you bump it up in your priority, basically.
Okay. Let's see. And we have Mr. Savage.
Hello, everybody.
Hi, Mike.
Hi. I just want to make sure I did that. Okay. I appreciate the opportunity to speak on this. I've got just 3 items. One is, I appreciate what Melissa had to say about improving clarity and consistency in the bylaws. And I want to talk about the change from 3 years to 2 years.
Mike, excuse me for a second. Are you and Christine possibly in the same room because we're getting feedback?
No.
Oh, okay.
So the 2 years to 3 years is that tying that to the special permit, I think, is unreasonable. Special permits happen far more infrequently than a preliminary or partial site plan review. Special permits, often because of the definition, have something special about them. They're higher profile, and they, again, happen infrequently. And so it seems more reasonable to require the applicant to act within 2 years of receiving that special permit. Preliminary site plan reviews happen more frequently. And in this case, where there isn't a state mandate that requires 3 or 2 years, I think you've made it more restrictive for applicants, which I think is not a good idea. I believe elsewhere in this article, for a full site plan review, you've asked for a little more time. You've also, for both a partial and a full site plan review, have asked for additional details on the material that an applicant has to provide. So in some cases, you've asked for more time, you've asked for more information to make a decision, yet you've given the applicant, or proposing to give the applicant, less time to act. And I think that's a mistake.
If I could just clarify, Mr. Savage, there is no time frame now. So it doesn't say 3 now. We're not reducing it. We're just putting 2 in there.
Oh, all right. So if someone gets a part, I think the current term is a partial site plan review. If they're approved, they have an unlimited time to act on that?
Yeah. Yes. There is no time frames now in the bylaw related to site plan review.
All right, we had a conversation on this tonight. Where did I come up with the 3 years? Did I just make that up, or?
Well, one of the questions from another resident said, why have you reduced the validity from 3 to 2? But there is no 3-year allowance. It's the bylaw is silent on the time to exercise that decision.
All right. Well, regardless, 2 years to me seems an unreasonably short time. I would expect most people to act on it, but there are situations where, extenuating factors may not limit that. And since the state doesn't require it, and to tie it to special permits, I think is incorrect.
We also have a phrase in the actual bylaw, which we haven't gotten to yet, that gives the applicant the ability to request an extension.
Fair enough. Question 2 is on the use, and it comes up as short-term rentals. I think it's number 37. And previously it required, and still does, a special permit. I believe also currently it requires a paragraph or a letter or something from the planning board. But it now looks like it requires a preliminary site plan review, or that's what's being proposed, which has, I counted 15 items, some of which I don't believe are required to get a building permit. So I bring this up because this summer, you may know, the World Cup is coming to Boston. 7 games are playing at Gillette Stadium. I might want to rent my house out. I do not want to submit all 15 items, easements, topographical elevations, all that stuff that someone who's building a garage has to submit just because I want to rent my house for a month. So I would ask that you modify that or make a carve out. And I understand we don't want to encourage short-term rentals in Dover, but we don't want to make them excessively difficult either in certain circumstances. So I'd like to see that.
Yeah, just to clarify, Miss, so right now you need a special permit.
Right.
And the site plan review is part of the special permit. The only thing that has changed is that the site plan review jurisdiction is staying with the planning board. So the what you need to get for permitting hasn't changed at all. Actually, one thing that we did include in the language when we talk about the requirements that need to be shown on a plan is that we have the ability to waive those requirements. And I'll give an example. If somebody wants to put in a pool and they're on a 20-acre parcel, we really only need to see sort of where they're going to be working. So as far as topography and vegetation, siting of the pool, grading, things like that. So those, we do have the ability to waive the requirements. So if somebody was, do we need topography? If somebody wants to, get permission to use their house as a short-term rental, that's something that we would be able to waive those requirements.
All right, I appreciate that, but that gives, the right to waive solely to the planning board. So it's
And me.
Well, could I just
The planning board is the one who's issuing the permit, so.
If it doesn't make the process easier, what you're suggesting, Melissa, because otherwise an applicant, for example, Mike, who might want to do a short-term rental would have to go to 2 boards for approvals. So we're not, in the absence of a change here, it's not as if the underlying site plan review bylaw goes away. We're just saying we're trying to make a change to streamline that. Am I right about that in my understanding?
It's right now it requires site plan review and special permit, and that's what it will require in the end.
But who would be the special permit body granting authority? Now
For ADUs, it's the zoning board of appeals.
No.
Today,
How about
it's
for short-term
rentals.
How about for
I'm
short-term
sorry. I'm sorry. My mind was on ADUs. Zoning board of appeals.
So my point is, it would be 2 bodies that need to be approving site plan from the planning board, then special permit from the zoning board of appeals. And in the case that you're proposing, we
No.
would be streamlining that to 1 body, the planning board?
No,
Okay.
no. It's the planning board for site plan. I'm just pulling out my drafts here, if you can bear
Okay.
with me. So I just want to be very clear on what I'm
Yep,
looking
thank you.
at. Yep.
In fact, the zoning board of appeals at their Thursday night meeting this week is handling a special permit on
Yeah.
short.
Okay.
All right. Excuse me, to Carol, to that point, what's the planning board's role in that application?
We have none.
Okay, so in the new proposal on the use plan, you have a role of performing a preliminary site plan review along
Correct.
with. All right. I think
Correct. So there is no site plan review going on by the planning board currently. The zoning board of appeals is performing that.
Yeah.
Part of this draft is putting the site plan review and for any project with the planning board. That's
All right.
where the expertise is, and that's where the capacity is.
All right.
The zoning board of appeals has no staff, Mr. Savage. I'm not sure if you know that.
Well, maybe we ought to staff them. So I'm sorry, but I think you've added excessive regulation to a short-term rental. Again, I understand the town's interest in perhaps not encouraging short-term rentals, but in this summer when the World Cup is here, I think it's an unreasonable thing to do, and I would ask that you remove it from this article. I'll go to the third one if I could. It has to do with this concept of intensification of use. And I've looked at this. I've looked at what other towns in the Commonwealth do. The word intensification is rarely used in any of the other towns. There are a couple, and when they are used in towns like Lincoln or maybe even Wellesley, they are very specific and they often relate to special permitting process. I'd also point out, for instance, that Melissa's former employer, the town of Braintree, doesn't have the word intensification in any of its bylaws. And then I also appreciate Melissa posting the red line of this part of the document, where she points out that the definition of intensification of use is both vague and subjective. So that led me to believe that perhaps she didn't initiate this concept of intensification, nor did she draft it in this document, which is fine. The planning board is certainly capable and appropriately can draft those things. So in this question, I'm respectfully going to ask someone from the planning board, because I think this issue came directly from the planning board. I'm going to ask that someone from the planning board please explain this issue of intensification. And I'm concerned that it adds ambiguity, a gray area. I've said before to the planning board that I'm focused on trying to, and Melissa affirmed it tonight, trying to keep the bylaws as black and white as possible. And I think this intensification of use, along with the phrase including but not limited to, when you're given examples of an intensification, adds a great deal of ambiguity to the bylaws that is unnecessary. So,
can I ask a question here before? I would just like to ask, to clarify, Mike, are you asking if a member of the planning board inserted that line or if Melissa did? Is that what you're doubting, that Melissa did, and you're suggesting that it comes from a specific member of the planning board, just out of curiosity?
yeah, the latter, I'm assuming it came from a member of the planning board.
Okay, but the answer is no.
May I assure you that it did not?
It did
And
not.
the implication is very interesting.
Not sure what you mean by that, Carol. Would you
And
care to
I know
explain
what I
that?
mean, the same by you. Okay, this was an attempt by the most professional town planner this town has ever had to take a look at a bylaw that we all know is difficult to use and needs an awful lot of work, and where we promised that we would start the process.
All right.
And I will defend Melissa on this. And I don't like the implication that this was something you have absolutely no basis for making that assumption.
I do have a
Melissa
basis
doing
for it.
what she thinks is best through best management practices and her decades of work as a town planner in towns that are an awful lot bigger with a lot more experience than Dover.
I think you misunderstood what I said. I never accused Melissa of doing anything wrong.
You accuse the planning board of inserting this. The answer is no, we did not.
Okay, so
That's why
Melissa,
that's why we're having a public hearing tonight, to not only get input from the citizens of Dover, but also from the planning board members.
fair enough. Melissa, if you're willing, could you
I
explain
am.
this? And in addition, could you explain it and then explain what you meant and what you meant when you said it was subjective and open to interpretation?
Yes. So, and I appreciate you looking at the notes. So I've been keeping notes, as you can see from the other drafts, and I think you were on some of the earlier meetings, of these sort of out loud questions that, we want the community and the planning board to weigh in on. What it said before, so these categories where we have our triggers for existing uses under site plan review. The first one is expansion. The second one said extension. And then the third one said change. So expansion, if you read that, it's fairly clear. Change in use, you read that section, fairly clear. Now I'm looking at this section and I'm saying extension, quality, and in extension, again, not meaning expansion or a change. And I felt as though that extension was not a good way to describe, if you look at what they were defining here, means a difference in the quality, degree, and intensity of a use that may have a different impactful effect on the neighborhood due to aspects including but not limited to parking, pedestrian, bicycle, vehicular traffic, lighting, landscaping, screening, and noise. So what I did in my comments, when I made those comments, and if you can see the changes, I changed extension to intensification, which I feel as though aligns better when we're talking about degree and intensity, intensification, intensity, and then also took out the wastewater and waste removal because we don't deal with septic as from the planning board. And frankly, it was a means to, again, I feel as though intensification of use explains that paragraph a lot better than extension of use. And
And your
that's how
note?
we ended up here.
Your notes regarding subjective and open to interpretation. Could you explain those?
That note was related to extension
I see.
and
So
it
you
not
think
being clear.
you
Yes,
think
these notes haven't been changed really in this specific section. I wanted to keep that in because this was something that we kind of were coming back to when I was doing my preliminary presentations, trying to, get direction so we could put together a draft to file. So I feel as though now intensification of use and the language that's there is a much better fit, and that it's much clearer what we're trying to capture when we say difference in quality, degree, and intensity.
I might give an example going back 10 years. It was the summer of 2015 where the Froyo store in the center of town closed, and Dunkin' Donuts came in to the planning board with their application. And whether it was under extension of use, it was my first planning board meeting. But to me, when I think back to intensification, the difference between a Froyo store and a Dunkin' Donuts to me fits an example of an intensification.
Okay, I didn't look at it too closely, but I do know there are lawsuits in the state of Massachusetts around the word intensification. I don't believe it makes things clearer or less subjective. I agree it's maybe no better than extension, but I think it's worse. So I would, I guess I will also apologize if anyone was offended by my earlier comments. I appear to be misguided in that regard. But I still think this paragraph in particular, perhaps more than anything else in this article, increases the subjectivity, the area of gray in the bylaws. And I think it ought to be somehow modified to make even clearer.
Okay, thank you. Mike, you still have your hand up? Is that from before, or do you have something else?
I've
There we
lowered it.
go. Okay. So at this point, I don't see any more hands up. So we can continue.
Thank you, Carol. So back to the table here, the ADU was never cleaned up when the bylaw changed. So again, you can see the attached ADU, and we have the preliminary site plan review, which is how we go about those in all districts. And then we also have detached, which previously required a special permit, and again, reflecting the preliminary site plan review requirements. I started to make some changes on the and thinking out loud about why don't we allow the wastewater treatment plants in the R2 zoning district. in the Conservancy District, and not having time to really kind of dig any deeper into that. At this point, I'm suggesting that we keep it the way it is, which would be putting back, the X's would be converted to no's. I just wanted to let the planning board know, there might be something deeper, and respectfully, I just don't have the time to put into trying to understand why they're not allowed in the R2 right now. Again, we don't have a large usage of those. I don't think this is going to be any kind of shift. It will essentially stay exactly the same as it did, stay the same as it is today.
Thank you. I just want to point out, Melissa, that's exactly what we have asked you to do too. So thank you for noting it, because again, we're not going to solve every problem in site plan review this year, but we're trying to chip away at the things that we think will make a difference. And I appreciate you noting that.
Thank you, Jody. Again, the changes that I've made here, again, it's to keep us current with state law and to update, to make changes to be current with other bylaws that we have amended, amended recently. And then there are some exemptions in state law for solar. As you can see here, that's something that I have town council looking at for us. So I should have an answer on that within a few days. And then everything else essentially stays the same. Moving along, any other questions on that stuff? We have some
Melissa?
hands up.
Oh, Melissa?
Yes, Val.
Just going back to the municipal use of the conservation or official space, did you need us to weigh in any more on that, or how? I mean, we had a discussion about it. I just didn't know what you were asking for this evening.
Yeah, so again, getting back, I apologize. I think we got segued a little bit. Thank you, Val. Yes, use 14, municipal use. Again, that's given that the official district is specifically carved out for that. You read the definitions. My recommendation would be full site plan review, including the Board of Selectmen. And that's, I think, what we did for, I wasn't here yet, but I'm pretty sure that's what went down for the fuel island.
Yes.
Thank you.
So does any planning board member feel that we should require a special permit for number 14?
It seems to make
support-
sense.
Yeah, I support Melissa's recommendation.
Me too.
Katie?
It definitely seems to make sense.
Okay, so there's your answer, Melissa.
Okay, I will make those updates in the drafts. Thank you very much. Moving along here, now we're getting into really sort of the meat of the site plan review, which is section 185-35, 36, which is going to be renamed partial and full site plan review. And before we get too deep into the text changes, the bylaw now, and I'll summarize, file a site plan review. It's preliminary. Maybe it's not. We'll let you know. Come to a meeting. That's not clear to me. So what we have is two distinct tracks. We have partial site plan review for accessory structures and ADUs, and then we have full site plan review for our business districts. And essentially, the bylaw creates two courses that have some similarities and then some differences as well that we can start to get into. One of the first things we did was rewrite the purpose. You know, what are we doing with site plan review? The purpose that we had before was kind of lofty, a little bit fluffy for my taste. And this is just very short and sweet and gets to the point. Site plan review is a means of evaluating land use by regulation of permitted uses, not their prohibition. So again, these uses are allowed. We have criteria. We're going to review those against those criteria, and we're going to put conditions as needed on these uses and structures depending on the particulars of every different case that we have. The partial and full site plan review process provides for a transparent review of accessory structures and buildings, accessory uses, and uses to ensure the health, public safety, convenience, and general welfare of the inhabitants of the town are protected. This process allows for site-specific application of the zoning bylaw requirements, taking into account the unique elements of the site's context and how the proposed use and/or structure will be in harmony with the existing neighborhood and environment. The process will determine if the proposed structure or use will be in compliance with the zoning bylaw without creating negative impacts within or off-site. And that's essentially, I think, if somebody's, what do you do at a planning board meeting? I really try to just put into words what it is that we do. I want to thank Jody for saying, Melissa, do something with the purpose. This is something that came from one of the board members. Again, we want it to be clear. What are we doing? And this is essentially what we're doing. The second part of this section is really where we will start to see a majority of the changes from what we do today. And that is allowing for some exemptions of certain accessory structures. Applicability and exemptions for partial site plan review. And we talk about 1 and 2 are essentially the same language. We just clean those up. Using structure and building. Again, a building is a structure, but a structure isn't a building. So we want to be clear. For example, a solar panel isn't a building, it's a structure. So we want to be clear in what we're regulating and using the appropriate terminology. Something that's new, and I have a lot of notes in the margin, and I would ask people to take some time to look at those. I have put those there so that everybody is, what is she thinking? What does she mean by this? And some square footages and things, so that things just, everybody's kind of on the same page as we talk. Number 3 here is new, and that is proposing to apply accessory structure in building setbacks to accessory uses on residential properties. And there might be some lengthy discussion around this. I've put in everything from patios, sports courts, trampolines, and playgrounds, equipment, noting that currently these things can be instituted right on the property line. So I don't know, Carol, if you want to open it up to the board. I suspect there might be some discussion. We can add, we can take things out. No offense taken whatsoever from the board members. Again, just want everybody to get a full understanding of what can happen today and what we may want to, discuss. Thank you.
So, there are probably a handful as we go through this, a handful of subjective decisions that the planning board needs to make relative to a draft bylaw that we present to the town at town meeting. And this is one of them. There's no right answer. There's no wrong answer. It's a very subjective thing. So I've asked Melissa to keep all this in so that we as a board can make decisions on what, if anything, we would like to remove or add. So for section B3, I
Yep.
open it up to discussion by the planning board members.
Okay, so just to clarify, this is a clarifying question. At the moment, if I wanted to put a sport court in my home, do setbacks apply?
Inside or outside?
Outside.
If it's a structure, yes. If it's within a structure, yes. If it's on the ground, no.
So for example, it's a sport court, and I imagine it's going to have pickleball lines and it's going to have maybe a basketball hoop. Is that a structure?
The basketball hoop itself may require a building permit. I'm not 100% sure. And the hoop itself, depending on the size of the court, might be out of the setback, but the court itself, let me say this, the court can still be on the property line and the actual hoop might be out of the setback, if that makes any sense.
So for example, if I'm just brainstorming.
Yeah.
if I put a sport court, had lots of different lines for lots of different games, and it included pickleball, and I wanted to put it on my property line,
Yes, you can.
could I do that?
Yes.
Okay. And so we are suggesting a change to that here in B3.
Yes.
Okay, thank you.
Yeah, I appreciate
also-
your
Oh, go
research.
ahead.
Oh, sorry.
Go ahead.
I appreciate your research on this, Melissa. I think I agree that sports courts should also have a setback to them. In particular, also because they tend to be impervious, depending on the type of sport court. And I think that there should be a buffer to allow for any of that water runoff not to go on to the abutting property, but to have that setback so that it stays within, preferably within that property, but also just to have any type of like noise buffer. If it's a sport court, there's balls flying around. Usually there's a fence, but there's not necessarily always a fence. I think so. I think it makes sense to have a setback for that.
Katie, you were going to?
Yeah, the only one, and I can't see, it's probably up in the comments there, and I should have it pulled up on my computer. So I agree with all of them. The only one I don't see is a setback requirement for playground equipment, how that term's defined, and patios. Otherwise, I feel the other ones, in my mind, seem legit requiring a setback. But I'm not sure how patios is defined and what would the setback be. And also playground equipment.
So
Is
a
it above the-
patio, yeah,
Yeah.
patio would be, some type of alternate treatment of the ground, to be used for, sitting, a grill, whatever it might be. And then the playground equipment is, somebody going down, I'll say the place on Needham Street, Newton, and spending $20,000, and they erect this jungle gym swing, fancy in the backyard. And again, that can be on the property line as well.
Yeah, I guess I would just say, what is the definition of playground equipment that we would use here?
Yeah.
Like, I see what you're saying, and I agree that it belongs there. Someone's going to build one of the jungle gyms, and kids are swinging to and fro. There should be in my mind, my opinion, subjective opinion, there should be a setback line. I'm just curious what the proposed setback would be for that playground equipment and how we would define it.
It
And
would be
also-
the same for accessory structures. So it's
the same. Okay, the exact
Yeah,
same. There wouldn't be a
so
separate one. Okay.
It's half of the primary is essentially what the accessory. So if the side setback in the R2 is 40, then this would need to be 20, similar to a shed or a pool. And then again, the term, I know the issue is that we have a lot of terms that aren't defined. And again, it's opening up the can, but really I want to stay focused on the site plan review.
Yeah.
And if there's concerns about, what does this mean? If there are things that we can always add to this in the future. If there's things that we have concerns about or they're unclear, we can eliminate those. And if there's ones that we definitely want to keep, we should keep those.
Well, they all seem to make sense to me, and I see no reason to remove any of them, whether I was the landowner or the neighbor next door. All of them seem to make sense and seem logical from my perspective. But I could see somebody wanting to get a definition of what that playground equipment is. I think we all know what we're thinking about when we think about that
Yeah.
setback line, but yeah.
I agree. And then, Melissa, is there, I'm thinking of like playground equipment, especially for a family who might have a smaller lot that may not have as much wiggle room for location. Is there a waiver opportunity for families, with playground equipment?
Variance.
Okay. And that would
Yeah.
have to go to the ZBA.
Yeah, it's a very, very, very high bar. Yeah.
Yeah.
Mhm.
So I guess I don't know. I kind of hesitate on the playground equipment, just only because of
too.
that reason with the smaller
Me too.
lots. Yeah.
I feel like we go down a kind of like a wacky road if we're like going to get into the business of regulating swing sets.
Yeah, I agree.
And trampolines.
Yep.
Yeah.
Yep.
Because trampolines, I think maybe by law, I don't remember in the state of Massachusetts, but I think they have to have like netting around them.
Also, they're not permanent. That's just
They're-
like, you know,
Right. You can move them. Yeah.
similar to a swing set. It's just like, to me, it's like it would never in a million years occur to me that I would have to get approval to have a swing set in my yard.
Right. I agree.
You know, I also think there's an aspect, and we see this not only in planning board, but in public safety issues and everything else, that a law that cannot be enforced
Right.
is not a particularly good law.
We don't need the swing set police.
Exactly.
I think that the sport court is sort of like the one that most comes to mind and I hear chatter about, and I appreciate your comment, Val, about the runoff, because I do think that's relevant, especially in tighter neighborhoods. And I think that the noise is the larger issue that people have a concern about, literally like a pickleball court in their backyard, or in their neighbor's backyard. So, you know, having some ability for neighbors to be aware of what's happening and have at least the opportunity to voice their perspective is, to me, protective for abutters without being super onerous for owners.
I agree.
So I think, Melissa, would you like us to take a vote on each of these 4 issues?
I think if I had to guess, we're probably just keeping sports courts. Is that what I heard?
I would support that.
Yeah.
I would
I don't
support
think
that.
we need to vote,
I
Carol,
support
because
that.
I'm still gonna
Okay.
clean up the drafts,
Okay.
and then the board will make a vote on the final language. But I really appreciate the discussion and the feedback. Very helpful.
Okay, so I see 2 hands up, Tom and Jonathan. If they relate to B3, I could take your comments now. I guess not.
I'm unmuting Jonathan. His hand is still up.
Tom is not muted, but his hand is still up.
Hello,
Yeah.
Yep. Is this Tom? Who's speaking?
this is Jonathan.
Jonathan, sorry. Okay, go ahead. Is it about B3?
Yes,
Okay.
but if I could just ask a couple preliminary questions. This is a public hearing. Has the board addressed this draft, or are they really looking at it for the first time? And are we going to have another hearing after the board has reviewed it so that we can comment? Because it seems like there's going to be changes to be made.
Sure.
And I don't want to waste everybody's time.
It's an excellent question, Jonathan. So this is the first time that the full board is looking at this. And we have the public hearing will be continued until our next meeting, which is next Monday, the 13th. And at that point, we'll be looking at a draft that Melissa has put together based upon the comments she hears tonight from both the planning board members and all of you.
Okay, so it might be better if I sat down with Melissa and went over some of my thoughts and comments. And then if she and I haven't come to an agreement on them, we can bring them at the next hearing.
Sure, absolutely.
That makes sense?
Yep, absolutely.
It does, but Carol, I apologize. If we can get as much out tonight, I just, I'll just have more direction. I want to try to just make one set of full revisions. And if Mr. Fryer has comments that the board may also want to weigh in on those as well. So I apologize for jumping in, but
That's okay.
the more input I get, the better. I've been begging, and Mr. Fryer has given me input in the past, but I'm so hungry for input.
So you've received input from the planning board on B3. Jonathan, do you have anything specific on B3 as it's currently written or intended?
No, not at the moment.
Okay, thank you. So let us move on then to B4.
Hello?
Oh, Tom, sorry, Carol, Tom here's, unmuted.
Tom,
Can you hear me?
now we can. Yep.
Ah, wonderful. Actually, I've had my hand up for a while. And my comments on B3 would have been in complete agreement with Jody and Val, and I think the rest of the planning board that sports courts probably make sense. Because for trampolines, playground equipment, I would never even get a building permit, much less look at the bylaws, right? So I think that's, Carol, to your point, unenforceable, because it doesn't even require a building permit. So I agree with your conclusion there. But my hand was raised as more of a point of order on the table, Melissa. The edits that you show are just the items I think that are going to change, right? It doesn't go in numerical order. It skips numbers, assuming because the ones in between aren't changing, right?
That's correct, Mr. Here. So
Yeah.
they're changing, they're going from like A to preliminary site plan review, but they're not, it's just changing the letters. It's not changing what's
Yeah.
happening from a permitting standpoint.
Okay. Yeah. Then my comment, super minor editing is, that the clean copy has both N and the word no and Y and the word yes. That probably just should be consistent. Pick one and run with it. So super minor comment. Just wanted to.
I'm sorry, Mr. Here, you said on the clean copy?
Yeah, you got, on one, there are Y's and N's all the way across, which is, I'm not arguing what those are, should be.
Yeah.
But then on 10, 11, 12, you have the word no instead of the
Oh,
letter
okay.
N. So like just an editing comment.
Yeah, no, I appreciate that. It's really hard to look at these over and over again. So the more eyes on it, the better.
I
Thank
know
you.
it. Yep. Okay.
Okay. Jonathan, can I assume that your hand that is still up there is down, given your recent comments on B3? Yep, there we go. Well, now he's back up there.
Overhand.
You're unmuted, Jonathan.
There we go.
Okay, great.
Okay.
So, Melissa, we can go down to B4.
Okay. B4. Okay. B4 is where we get into some exemptions and truly saying what structures are people putting up, accessory structures that tend to not have comments, a lot of comments from the board, more common accessory structures. And what I've done here is I've called out garages, and I would refer to the margins for all the different sizes in which you come up with this. And so garages under 1,015 square feet. So that gets you essentially a 3-car garage that is, and I apologize, I have a lot of different windows open and I can't see my actual margin. So, but basically 26 by 26, I believe we're up to 26 by 39
Yep.
for 3-car garage. So that's where that comes from. And then again, being very clear that on the second floor, it's just storage. There's no party room. There's no workout room. There's no come up here and hang out and have a couple. None of that type of space, storage only. Typical garage from, 20 years ago, 30, 40, 50 years ago. Sheds under 1,000 used only for storage. So equipment, pool equipment, lawn equipment, whatever it might be, things you don't have room for in your basement because it's finished and it's beautiful, whatever it might be, storage only. Excuse me, all swimming pools, in ground and above ground. And then had an idea maybe sports courts was something that we were going to get into. And again, looking at the sizes, so I'm proposing sports courts under 1,000 would be exempt from site plan review. partial site plan review. Very important thing to note that the use table says accessory use. And if we look to the definitions, that is not just buildings. It specifically says accessory use or building is a use of land or building. So that falls under that definition of accessory use and that category of accessory use. So those are the things, again, that I feel as though are more common and are things that can be connected with a building permit.
I love the idea of having exemptions like this. You know, swimming pools pops right out at me because obviously we always go through the exact same rigmarole with the swimming pools, and we all know like what we have to ask, and it doesn't seem like a good use of the applicant's time or ours. So I'm totally down for that. I think that garages makes a ton of sense. The sheds feel like super big to me, and that's just totally
Okay.
subjective. I don't know what that's based on, but like 1,000 square feet is bigger than an ADU that we allow, and they have, you know, there's hoops to jump through on that front. But I appreciate the thinking that went into these, and you know, definitely support exemptions, and maybe, you know, we just have some really good clarity on, for example, why we chose under 1,000. Maybe there's some other towns that exempt sheds at that size, and that's sort of defensible. I just don't want to, you know, I don't know enough, so appreciate you
Yeah,
on that. I
I
can
had it
add
at 400.
400, and then you went to 1,000.
I know, because I was just thinking about sizes and impacts. And again, if this is just for storage,
Right.
like what's going to change from going from 400 to 1,000, you know, and just trying to create some uniformity
Yeah.
with the garage, the sports court, and being around, you know, the same general area.
Yep. I hear you. Thank you.
I would also mention that one of the reasons that we were doing swimming pools was because of the condition that the pool had to be filled by a truck and not from a well. The Board of Health, as we speak tonight, actually is beginning a review of their pool regulations with the expectation that they will add that requirement into their regulations, which haven't been looked at in decades. So that major concern, which should be a concern to all of us, will be handled through the Board of Health.
Great.
Val and Katie, thoughts on these exemptions?
I totally get behind the pools. I think that they're pretty straightforward, and there's enough regulations in other departments as well as the state to support not needing us to review those. I'm a little more hesitant under the garages and sheds. I agree with Jody that the size, I think, is something that I would be very interested in discussing a little bit more. And also I'm just wondering about, and I think Melissa, you and I have spoken about this, what determines storage versus some other use. So I had suggested maybe defining like a garage that does not have a full bathroom as something, but you know, I just think that the larger the garages or the sheds get, the more I think that it's important to have a butter input. And I can give you some specific examples as to why I think the site plan review, as we talked about at our town meeting, is so important, is because of that abutter input. And I know living on Haven Terrace, there have been some issues with even engineering and staking of lot lines. There was a pretty significant mistake that was made by the engineer when the lot lines were being staked. And so I think having a butter input to kind of validate, you know, where lot lines are, what impacts might be on abutting properties or detriment to the neighborhood, I think are really important pieces that you don't get when you just have the building department reviewing and implementing these.
Katie?
Well, it's interesting. I guess I thought Along Val's lines, I was thinking, I like the idea of all the exemptions. I also like the fact that you kept it 1,000 square feet, because I agree with you, Melissa. It makes sense. What's it matter? Who cares if it's for storage? Dare I ask how we cannot, and this just goes against, I think, a little bit of what Val's trying to address with her concerns, but I was thinking, is there another way that we could maybe expand the exemptions for the garages?
So, I appreciate everyone's comments and sensitive to everyone's comments, and everyone has a little bit of a different perspective. So, if I have a huge property and I put in a shed and I'm a huge gardener working outside all the time, and my house is literally like 4 acres up a hill, and I have all my gardening equipment and my mower and my cute little gloves and all my fun stuff that I store in my shed, but I put a toilet and a sink in there. To me, the bathroom doesn't necessarily change the use. It could if somebody starts doing something else by storing it. But depending on how your property's made up, like if you have a pool and you don't have a pool house, you might put a bathroom in your garage so that the kids aren't coming in and out all day. So I think there's a lot of different instances. I personally and professionally don't necessarily think the bathroom is the trigger. It's really, how is the structure being used? To me, a garage is for the parking of cars and your quote stuff, the stuff that doesn't fit in the shed, your barrels, maybe your recycling bin, the spare fridge, the freezer with some extra steaks, that's stuff that goes into the garage, a vacuum, whatnot, storing some extra things. And again, that's why I was very specific when adding. I didn't just say shed, I said specifically shed used for storage, because sometimes people like to use their sheds as a workshop or as a little man cave or something like that. And this is specifically, again, my opinion, if somebody is just storing their yard equipment or garden equipment or even pool equipment, let's say they don't have the cabana, I really don't see that as something that's going to generate really impacts to abutting properties.
And additionally, you'd have the oversight from the Board of Health if somebody wants a toilet in their garage or their shed.
Yeah, if they put plumbing in, then there would be the connection. And then, and I've even seen the Board of Health staff, Jason, he puts deed restrictions, because he wants to make sure that, when he allows a sink to be, or a toilet to be connected to a septic, that it doesn't come along with showers and laundry and all the other things that really, exacerbate the septic situation.
Maybe some of our reticence on this comes sort of from, before. I feel like I don't know if this is even like fair, but it's kind of popping into my head. I feel like over the years we've seen sort of more pool houses, more expansion uses that were sort of outside the bounds of original intent. And it feels to me like as we continue to be more clear with our bylaw, we'll see more, like, people don't have to beat around the bushes, right? If you want a pool house, just say you want a pool house, because I think that's what maybe you're hearing from us. And I don't want to speak for you, Katie or Val, but concerns of sort of, it's going to be one thing, but then it turns into another. And I feel like the more we clarify, the less we have to worry about that.
Yeah,
There
no,
is
I
a
was actually thinking
pathway.
about expanding it so that it doesn't have to come under site plan review for garages that are attached, not detached. Like,
Attached don't come now.
okay.
Only
So
detached.
for the
Only
detached, yeah, I didn't know if there's
yeah.
any way to expand it. I like it. I just wonder if there's a way to expand it a little more, but maybe not.
Well,
maybe
this is a
only
pretty
saying with
big
no use as a
expansion.
second floor except storage. We couldn't add something else that could also, expand it besides storage. Like, why can't they put their Peloton bike there and work out? I mean, I don't know. I'm looking for ways to expand it
Yep.
so that the planning board can focus on things that we can assist. I just don't know why a butter input, using my one example, would be needed if someone wants to put their Peloton on the second
Right.
floor of their 3-car garage and work out there.
Right.
So I was wondering if there's a way we could expand it.
Yeah, I'm
But-
not saying that people can't put their Peloton there. I'm saying if we're talking about using something for storage, then why would there need to be a full bathroom with a shower, right? So if somebody wants to even put a sink, like a utility sink in their garage because they've got a workshop in there, fine. Like, we're not saying no plumbing. We're just saying if you have a full bathroom, that to me is no longer storage. If you're talking about storing your garden things in a shed and or a garage, I totally agree. But when I think of storage, I think of something very bare bones. I just don't think of a full bathroom in it. So that's why I just felt like kind of defining that a little bit more might make sense. And I also, again, when we're talking about a 1,000 square foot building, I just think it's nice for abutters to be able to have input on those. I think that we can think of a couple examples over the past couple of years where it's actual abutters who bring attention to certain issues that the building department has overlooked. So I don't know. I think we're talking about I think they're kind of sizable. A 3-car garage and a shed basically is also the size of a 3-car garage. That's pretty big.
So I tend to think in terms of where Katie's going with this also. I think that with OpenGov, which has made a huge difference in the way the land use departments work together to look at every single application.
Mhm.
So that when a building permit that may or may not require planning board, let's say does not require planning board, comes before OpenGov, it pops up and a town planner can take a look at it, or Board of Health can take a look at it. And it allows our land use staff to opine and comment on every application that has come in, regardless if they have a regulatory responsibility to respond. So I think some of the issues relative to whether one department or another has sufficiently looked at a situation is somewhat mitigated by OpenGov now at this point.
Yeah, my concern is more like the size, and I know that's also governed by setbacks and lot coverage. So there are gating issues at hand. It's less to me about what goes on in the building because, whether somebody wants to ride their Peloton in their second level of their garage, I could care less. It's more like from an abutter perspective, again, what's the right size? But I appreciate your point, Carol. I think that's a good one. It does provide us with a little bit more eyes on, which is, I think a good thing for residents generally.
Yeah, and of course, OpenGov, I mean, we use it to look at our applications, but do keep in mind that anybody can get into OpenGov
Right.
and look to see what applications. So if they want to get into OpenGov and
Right.
search for
To see what's going on.
Cross Street, they could see what's going on.
Yep.
Right. The other aspect is that have to remember the one of the ironies of this whole thing is that if you're building a new home,
You're
regardless
right.
of size, there is no abutter notification
Right.
whatsoever. There's no site plan review. There are no controls. It's just based on whatever the state building code and
Yep.
Concom and Board of Health.
Yep. That is true, true, true.
So let me go back to the attendees now. And I see that both Tom and
I'll go
Mike,
to Tom first because he's
Yep.
on the top.
yep, and this is on
Oh,
B4.
he's unmuted. Yep.
All right, thank you. As you can imagine, I'm a fan of this. I think it'll dramatically reduce the number of what I'm going to call nuisance site plan reviews for the planning board of things that are just normal. Now you can argue whether 1,000 square foot shed is normal or three-car garage. It actually brings us in line with Medfield's bylaws, but they allow a three-car garage without defining the square footage. So definitely a fan. The only thing I would comment I have is actually limited to be clear about the 1,015 square feet of the garage. That means the footprint, not necessarily the square footage as you would calculate for a house, right? Where the second floor mezzanine might count as square footage. I think we mean the footprint, not the entire square footage of the structure. Is that, do I have that right?
With the garage, yes. And again, typically it would be just a dropped in, maybe it'd be a full set of stairs, but a mezzanine above.
No, exactly. I'm not, and
Yeah, I'm just trying to like talk out loud about what that kind of like looks like. And then I haven't seen any two-story sheds, but it would be the garage would be the footprint.
yeah, I'm
Um,
suggesting just add those words
yes.
in there, footprint.
Yep.
Yeah. Yep.
Yep.
Yeah, that's a
Got
good
it.
point.
Yep, I have that note here, clarify footprint.
Would you folks mind if we take about a 3 or 4 minute break?
Sounds good.
Unless you want to take Jonathan's question.
Well, we'll do that right after we take the break. Thank you.
Okay, thanks.
I'm okay.
Okay, Melissa, do you want to take your break?
I already went.
Oh,
I like literally like ran and like I could still hear the computer from the other side of my house.
I was trying to be discreet.
Yeah. No,
and
I
saw your
appreciate that.
message. Okay, sorry.
I appreciate that. I'm just going to stretch my legs a little. I think a couple other people might have needed one too. Thank you, Carol.
Okay. Okay. So let's take a very quick break for a different reason than I was asked for originally.
Coming in to see the boss.
Okay, so let's see. Melissa's back. So let us proceed, and we still have a couple of hands raised.
Yeah, we have Miss Savage. Let's see. Yeah, you should be able to speak.
Yes, hello. Can you hear me?
Yep.
Fantastic. I also support the idea of having specific exemptions. I was going to make the same point that I think Tom made, which was that square footage number should be explicit and refer to the footprint. I mean, for anybody who hasn't participated in this conversation, it wouldn't be clear. I also happen to believe that there isn't enough of a difference between a garage and a storage shed. So I think it's entirely appropriate to make those maximum square footage numbers the same in the spirit. And we talked about consistency earlier. I think in this case, it would be appropriate to make them consistent. So whether that's 1,015 for each, or 1,015 for garages and 1,000 for a shed, I think that's the way to go. Thank you very much.
Thank you. Justine.
Yeah, hi. I guess I am concerned about garages and storage sheds becoming ADUs de facto. And so I would urge you to consider, in the essence of consistency, go to 900 square feet. It seems to me if I wanted to get around rules, I would say something's a 1,015 square foot garage, and then I'd put in a lot of bathrooms and put in a microwave, etc. And I could probably sneak in some people either through Airbnb or through ADUs. So I would encourage you to think smaller, not bigger, and to definitely consider outlawing or minimizing bathroom facilities.
Thank you. So, Justine, I think if you're done, your hand is still raised. Okay, there we go. Are there any more comments from planning board members on B4?
None for me. Thanks, Carol.
Okay.
I would agree that I would like the board to consider reducing the size of the garage and shed. And requiring no full bathroom.
Okay, any other comments from planning board members on that? Melissa, do you have what you need to proceed with B4?
So I'm just kind of gonna summarize and maybe respond a little bit. You know, if we're the size that I've put here and for the garage is pretty much like a standard 3-car garage. Giving enough room for an SUV to open the doors, get out car seats, all that fun stuff. Again, if they're parking cars in there and there's a bathroom in there, is that not a garage anymore? That's sort of the question. You know, would you call that something different if there was 3 cars parked in there, a lawnmower, some trash barrels, and there happened to be a bathroom?
What if the bathroom's on the second floor?
Well, the second floor can only be
seems
used
me-
for storage in the
But,
garage.
but they could say, anyone could say, yeah, it's just storage, but I have my bathroom up there so I can have more space for my cars. Or I have
So-
more space for my riding lawnmower, whatever, you know.
So this is what, like before, after, during? I'm just trying to like understand. So somebody gets a building permit and they erect a garage, and then they want to put a bathroom. Let's say they come in and get a permit because they want to put a bathroom on the second floor. And nothing else is changing. And they're still going to store stuff. I mean, I don't think the bathroom changes the use is my point.
Yeah.
And I think we're getting a little bit, you know, we're getting into an area where now saying that because there's a bathroom there, it to me, it doesn't change the use. And that's where we're going to get a little, you know, into a little bit of back and forth, which is always healthy when talking about zoning. I guess that's just my opinion. The bathroom doesn't change the use. And I really think going down the bathroom road, the whole thing about ADUs and de facto, it's again, there's going to have to be quite a bit of improvement. If somebody wants to bootleg something, they can bootleg it in with or without site plan review. If people want to get, you know, to that level and institute uses that haven't been properly permitted. But the path for ADUs is so simple that I don't see why you wouldn't want
Right.
to go down that, go
That
through
was the
that
point
path.
I was making, is the more we talk about it and become more clear in the bylaw, we can sort of streamline and avoid some of that bootlegging, which I think is an underlying concern. But beyond that, like beyond the bootlegging, I personally think like if somebody wants a bathroom in their garage, like it's kind of none of my business. Like, why do we care? I guess is the thing. Unless you're concerned that somebody's going to turn it into this like illegal ADU and have some parties. I don't know. It just like gets to the what do we care about and why do we have site plan review? And it's
That is, I totally agree that to me, one of the reasons why we have site plan review is to offer the ability for abutters to weigh in. So, I mean, honestly, I'm fully behind the pool. The garage and the sheds, I kind of think it's one of our jobs to review those. So, if we did a smaller size that has less impact on the surroundings, great. Yeah, I don't know.
I hear you.
I mean, in looking at the bathroom, the structure would have to be substantially changed for it to be a fully functioning bathroom year round. You have to now insulate and heat the property. Otherwise, what do you do during the winter? All those pipes would freeze. I mean, so there's a substantial change in what that
Right.
building would be to sort of begin to
Substan-
make it more usable by putting in a full bath. I mean, I think that's part of the discussion we have right now regarding trying to convert some sheds into ADUs. You can't just do it. The building requirements are different, but now becomes a building enforcement.
Right. I think Eric, I think I'm seeing it the way that you're seeing it, which is by having a bathroom, it becomes much more than storage, or has the potential to become much more than storage. Storage is a very simple, in my opinion, a very simple structure that doesn't have a lot of finishes. But when you start talking about all these other finishes, to me, it just becomes more than storage.
Correct.
But respectfully, the finishes, if somebody wants to deck out the inside of their shed, the finish doesn't dictate the use. Like we need to, like if somebody wants to put curtains and tiles
Right.
and paneling, like respectfully, that doesn't change the use.
And if somebody puts a bathroom in their second floor garage because they want to ride their Peloton in there, it's the same thing if it's still used for storage or something like that. I still think we should give people the out here and not burden the planning board with things that probably are not that important. I don't think we can assume that everyone's going to try to get around the
Right.
ADU requirements when they secretly want to have it be an ADU.
Right.
I mean, I think we
Just
can't
build an
just
ADU.
assume,
Right.
right. We just can't assume everybody's guilty of doing something else. I think we should give some people some leeway here with their 3-car garages, which tons of people have in Dover. Everybody's got them.
No, and I don't have a problem with that. It's more allowing abutters to know what's happening around them. Because this is an exemption, which means that there is no site plan review.
Yeah, that's what I mean. I don't think abutters need to know that. I guess that's the site that I'm on. I don't think abutters need to know about those things. It doesn't seem important. Why should an abutter care? But that's my opinion.
Well, abutters don't know when somebody, clear cuts a piece of property and puts up a 12,000 square foot McMansion. Right? They're not made aware. They come home one day and suddenly a treed lot is bare. And the building department currently has absolutely no requirement to notify abutters of what's going on. As to Val's point, as was said last year, on certain types of site plan reviews, and that's what we're sort of wrestling with right now. then a butter notification is beneficial and something that we all as abutters, depending on what side of the coin we are at the moment,
Right.
would appreciate. And what they're wrestling with is not a butter notification so much as, to Katie's point, what is it that is concern to the town of Dover and to its residents about what goes on different pieces of property
Right. On the inside.
on the inside? Exactly. And the fact of the matter is that there are controls already there.
Board of
So
Health,
we've had these
building
conversations
setbacks.
at planning board meetings where if neighbors feel that something is being used differently than the permitting that was done, whether it was a site plan review or just a building permit, then there are ways to address those, whether it's going to the zoning enforcement officer or looking at what's been done as far as DBAs and so forth. So there are remedies to not knowing or remedies to seeing a change or perceived change. And those exist today and they'll continue to exist.
If somebody, excuse me, Carol, I just want to give an example. If somebody builds a shed and then they go and pull a building permit for a bathroom, at that point, you know, like Carol said earlier, we're on OpenGov, we look at things, we have dialogue. What's the intent? What are you going to do? And if there's a concern that the use is changing from something that is exempt, then they would need to come to the planning board. That's no, you know, we've had other cases where people have come to the planning board and then wanted to change something and then they came back. If somebody's going to do something they're not supposed to do, I feel like they're going to do it anyways, with or without, you know, people come, they get permits, they construct things, the inspection's done, and, you know, there goes then, you know, a bunch of other work happens. I feel like if the type of people that are going to do that are going to do it anyways. And again, I just, these going back to like, what are the common things that we see in Dover? What do people need typically to operate? And most people in Dover, from what I've seen, have garages, sheds, and I'd say probably half have pools. They're very, very, very common. These are things that, you know, it would maybe be unusual if you moved to Dover and your neighbors had nothing going on whatsoever, aside from the main structure. Keeping in mind that if the garage is attached to the house, it's allowed, you know. So sometimes if you think about a specific site and planning and layout of that site, sometimes a detached garage lends better to the natural topography or landscaping of the lot. And I would hate to be in a situation where somebody detaches the garage to preserve vegetation or view corridors or something like that. And because they've opted to go with something that's friendlier for the lot and for the neighborhood, that they have to go through this process. And again, I haven't been here that long. We're going to be coming up on a year soon. But again, just looking at the applications and what comes in and the comments from the planning board, who's there to ask questions. It's limited on with these types of uses.
Okay, I think we'll move on from B4. Planning board members and attendees, if you have any additional thoughts on B4, please, you have the opportunity to contact Melissa outside of this public hearing.
So now we get into the applicability for full site plan review. We went over the applicability and exemptions for the partial. There are no exemptions on the full site plan review. We direct people to the use table, which is now, as I had mentioned before, there's going to be a box and it's going to tell you exactly where to go and what type of permits you need. And then 3 essentially is the section where if you need any form of site plan review, what this section says is you're getting it from the planning board. The bylaw is split on special permits. The planning board issues some special permits and the zoning board issues some special permits. And that's specifically what this section says. I don't know, Carol, if you want to take questions before we.
Oh, let's see, what do we have here? Oh, Jonathan? On C3? You're-
No, I don't think I have anything on that, believe it or not.
Okay. We saw your hand up. Okay, Melissa, continue on then, please.
Yep. Moving on to the next section, which is the general requirements for partial. Wait a second here. Oh, that should say partial and full site plan review. I need to correct that. So these are general requirements that apply to both processes. The first one, those of you that are familiar with the bylaw, it says when you're in the official or open space district, you're going to go to the planning board, but the selectman's going to do something and they're going to make recommendations and talk and whatnot. It's not very clear. We had an application a couple months ago for a property in this district. I made a recommendation to have a joint meeting. And that worked out very nice with the planning board and the board of selectmen. One meeting, more efficient, everyone's there, everyone asks questions, everyone hears the answers, and they have the benefit of the staff report. And also in that particular case, and working with the town administrator, I wrote one decision and the planning board signed for their vote. And then the board of selectmen also signed for their vote. So just another way to build in efficiencies. Very confusing when you have multiple boards issuing the same exact permit, essentially. Number 2 here is the 2 years. I know there was some discussion earlier in the meeting about 2 versus 3. I don't know how the planning board feels about that. And again, you, as Carol had noted earlier, you can make a request for an extension. If you're financing, if you had a family situation, well, a work situation, you couldn't find a good builder, the guy you hired ended up being a flake, whatever it might be, there's reasons. Some were discussed this evening. So you can get extensions on that. And number 3 is the peer review. If in fact we need to invoke a peer review. Just entered in the state statute, which is 44, section 53, and then also referenced another section of the bylaw where the review fees are mentioned. Now we get into E, which is the measures and performance standards, however we want to describe them, triggers for existing uses and when they might trigger site plan review. We talked about these a little bit earlier with a comment from the audience. 1 essentially stays pretty much the same. 2, where I took out extension and put in intensification, I think that is clearer and aligns more with what that paragraph describes. And then we have the change in use, which is pretty clear. I don't know if we want to talk about those at all, Carol.
Well, I think we discussed those at length when we were going through the questions
Okay.
that we'd received. Though I will ask the planning board, the planning board members, do you have any comments on the issues of these definitions and the use of intensification and the changes that Melissa has made?
I don't. I'm all for more clarity.
I see Katie nodding.
Agree. Sorry, I was on mute. I agree.
And Val?
Yes, I agree too.
Okay.
Okay. Now we get into the application process for the partial site plan review. So we have the path for partial, the path for full. Everybody is encouraged, obviously, to talk to the town planner. A lot of that has been happening, which we love. People come down, or they saw my comments on OpenGov, meeting a lot of people and talking to a lot of people about whether or not they need to file with the planning board. What are you doing? I have an opportunity to ask questions. They can also ask questions as well, talk about meeting dates, whatever it might be. Make myself available to go over things, meet with engineers, whatever is needed to provide clarity and to assist residents through the process. We now have a list of plan requirements, which is great. These are pretty standard, and we have put in at the bottom, please note, town planner and the planning board may waive site plan content requirements. I had given that example earlier. And you're on a very large lot. There's no need to survey 20 acres of land if we're putting in a pool house cabana. So again, making sure that we have the information and we know that the site and what's being put up on the property meets the setbacks, how it's situated, and that we have the information so that we can make the proper findings. That's really what it's going to come down to. If we don't need that information to properly evaluate an application, then it can be waived. And the town planner has that discretion. So when working with someone and they're working with their engineer, I can say, hey, don't worry about E, F, and G, just making an example, picking some random letters. In addition to the site plan, we need a project narrative. We need exterior elevations and floor plans. Certified abutters list, one set of envelopes, and a deed for the property. So this is actually already all in OpenGov. Things have been working great. Folks have been getting the abutters. Half the time we have the abutters list and we don't even have the application yet. So things are working out very nice with the OpenGov. Abutter notices are being sent out in a timely fashion. Public hearings, etc. So things are working very well with the OpenGov platform. And we have put in here our courtesy notices that were now instituted in the bylaw for the partial site plan review, direct abutters across the street or across a water body. And we typically mail them out even sooner, but we want to make sure folks get that in advance to be able to either go on the OpenGov and look or call me at the office. We send people plans, we email them, whatever the format is that's more comfortable. A lot of people like to come down. We just want to make sure that people get the information in advance of the meeting. D is the section on the 30-day time frame. And I had made a note earlier in the discussion, the intent is always that is mutual. We will clarify that in the bylaw. And then one of the last questions I had, and I'm going to be talking to town council about this, is what do people do now if they want to appeal? I guess it would be preliminary site plan review approval now. I just want to talk to Nina a little bit about that. My gut tells me to just go with 40A section 17 because that's the clear and process laid out in state law. But I want to just discuss that with her in a little more detail. The review criteria has been condensed and cleaned up, even more so from the most recent red line draft and clean copy. This version here and the memo, for the purposes of the memo, has been cleaned up with these blue lines. Again, making sure that what we're looking at makes sense, correlates with things in the planning board's jurisdiction, and things that were unclear and a little bit too interpretive have been removed. So I think we have a good set of criteria now. And that really summarizes partial. Carol, I don't know if we want to pause for comments before we get into full site plan review.
Sure do. Planning board members, any comments and questions about partial site plan review?
None for me. Thank you.
Anyone? No?
Oh,
I don't have any.
do.
I do, I'm going to, right now, I don't see any hands up from attendees relative to partial site plan review.
One keeps going up and down, Mr. Fryer.
Want to be heard.
Well, it's down now, so. Okay. I'll continue, Carol.
Mine says up.
Oh,
Oh,
now
it's up now.
Now it's
Now
Mine
it's up.
says down. Lower hand. All right, it's up now.
Okay, Jonathan, do you have a comment on partial site plan review?
Yes.
Okay, please.
Okay, so right now, partial site plan review does not require a public hearing. Is that correct?
And the current bylaw, preliminary,
Yeah,
Right.
but also in the new one.
and the new one, yes, none. Yep.
Okay. So my understanding of a public hearing is typical of not having a public hearing is abutters do not participate. It's the board that deliberates. Public hearing gives the abutters an opportunity to speak. So why do we give them notice? And now why are we requiring certifies abutters list when it's not a public hearing? All we do is cause trouble in the neighborhood. I put that out there. I not only don't think it's necessary, I think it's counterproductive. And that's it.
Thank you for that comment. Any other comments on partial site plan review? Or abutter notification? Okay, full site plan review.
And just for a point of information, Carol, the planning board sending out those notices, it's correct. It is not a public hearing. The planning board can opt to not hear from the public if they don't want to, or just because it's not a public hearing doesn't mean the planning board can't. It can go both ways. I don't think there's any harm in either or of those. Application process for full site plan review. Again, talk to the town planner. What are you doing? What does that look like? What decisions do we have? What's going to be the path for your particular project? Full site plan review requirements. Again, we have a detailed list of plan requirements. This list has additional items beyond the partial. And again, the opportunity to waive those, similar to the partial. For our submission requirements, very similar. In this particular case, we're looking for a little bit more beefed up architectural plans, including renderings, and in some cases, perspective. So again, looking at relationship in our business district amongst existing and proposed structures. Project narrative. We also have an opportunity here for additional studies, which are very common when we get into larger projects, whether it be traffic, noise, lighting, air quality, fiscal reports, all those things come into play. This section D does specifically say that this full site plan review requires a public hearing, and it references the state law and who will be notified. And when they will be notified. We're pulling that right out of the state statute. It's typically newspaper 2 weeks in a row, legal notice going out to certified abutters 2 weeks before, and then also notifying the abutting communities as well. So we'll get the abutters list. The lists have always been certified, or at least since I've been here. We just want to make sure we're capturing the newest resident. And then also a deed, current deed for the property. This section specifically talks about the planning board in a full scenario having 60 days. And again, the same, provisions for extensions that will be clarified so that it's very clear that it's mutually agreed to. And then I don't know why that's B. The pagination on this thing was enough to drive me up a wall. That should be F and say appeals of full site plan review shall be filed in accordance, again, Massachusetts General Law, Chapter 40A, Section 17, standard process. Do you want to pause for comments, Carol, or do you want me to keep going?
Well, let's keep going.
Okay. Moving along to the review criteria, same as the partial that has been cleaned up. And then the last part of section 185-36 is the as-built process, which happens sometimes, doesn't happen. I think it's important in both settings to make sure that we get an as-built plan. For example, I'm looking at an application now that the house was built quite some time ago, more than 10 years ago, beyond the statute of limitations. And I see the house is 39.5 feet from the lot line. Well, I'm, of course, looking at it for an accessory structure, but I noticed that. And I'm saying, an overhang, the foundation. Sometimes things are off, and it's important to capture that in real time and not for somebody like the town planner to see that 20-something years later on a plan. So getting as-built plans, making sure that the conditions have been satisfied. This is how we have set up our workflow in the OpenGov. And it's just a very common practice again. There's always going to be some exceptions from time to time. Landscaping's a big one. They finished the project in December. Well, no one's going to plant in December. Typically, people will post bonds. Again, the gamut of these accessory structures and the planning board, it's important to note, we go from, the smallest I've seen is 280 square feet up to 27,000. So very different scale and very different type of site work and attribute and different things that go into creating these larger structures. And it's important to capture all of that. And then this last section here was just old language. We used to do these tri-party agreements and passbooks, and, the bank would say, yeah, he's got the money in the bank, give him the CO. Well, that's a little bit archaic for my taste. So cash is always acceptable. And we would hold that money or a surety bond, which is really what most people end up doing. They post money for a bond and the surety company guarantees the improvements. So we make sure that everything is completed as approved. And that's the end of the 185-36. We have one more section after this, Carol, which is the section about the Board of Selectmen.
So on 185-36, a lengthy discussion, I think very beneficial for all of us, and I appreciate all the input. If there's more input, please get it to Melissa in the next couple of days. Remembering that the townhouse is not open on Fridays, though Melissa is spending an awful lot of time on Fridays supporting the planning board, but let's see if we can give her a break before the continuation of the hearing next Monday, so that we have a draft that really incorporates everybody's thoughts and doesn't really come up with new stuff on next Monday. Melissa, can we literally, 185-40, you've already spoken about earlier on about the process with the Board of Selectmen, so maybe,
Yeah, that's basically what we've done. Yep, basically what we've done, Carol. We've created we've removed that extra step in pulling the selectmen over to the planning board side, town planner, so that we can have one hearing, get all the questions and comments out, all the testimony, I think it's much more beneficial for the public, for the applicant, and for the regulatory boards here. And that's basically what this says.
Okay, well, this has been great. I'm going to make a motion now to close the public hearing, to continue the public hearing until Monday at 7 o'clock, April 13th. That's a week from today. At which point we will get any final comments, and if possible, we will take a vote on the bylaw, since that's only 3 weeks from town meeting. So, do I need to take a vote to continue the meeting?
Yes, Carol, a second and a vote, please. Yes.
Second.
So, thank you, Jody, and we'll take a vote now. So, Val,
Yes.
Katie,
Yes.
Jody,
Yes.
and Carol, yes. So, to the 5 or 6 attendees tonight who provided their comments, thank you very much. And please feel free to communicate with Melissa between now and Monday. It goes for the planning board members as well. So with that, we're going to move on to item number 2B of the agenda, and that's a preliminary site plan review for a shed at 3 Tubrick Drive. I'll turn it over to Melissa and apologize ahead of time for those folks that have been waiting for this.
Yeah, I see Kathy and Mark here. Yes, let me promote them to panelists. Okay, great. They should be coming up.
Yeah, can you hear us now, Melissa?
Yes, we can. Mark, is that you?
Yeah, this is
Okay.
Mark, and I have Kathy here with me.
Hi, nice to put a voice to the emails.
Right on, likewise, thank you.
Yes. So very quickly, for the board, we obviously have Mark and his wife Kathleen here. They made an application through OpenGov for their property at 3 Tubrick Drive, and they're looking to put in a 20-foot by 14-foot shed. It's about 280 square feet. I do have an aerial photo here with a little yellow dot. The garage is essentially going in the side yard. It's the best way to describe it, as it's shown here on the certified plot plan. This is this offset that I was talking about earlier. That's 39.5 feet. So just interesting how minor things change in the field. This is nothing negative on your application, Mark and Kathy. I was just using you as an example. I hope you don't mind.
Right.
So as you can see, the shed is inside the setback line there, kind of a little angle off to the side yard. Got these renderings here from Mark from Reed's Ferry. You know, your standard shed, again, very typical. Got the little cupola on the top with the dormer to dress it up a little bit. Very nicely done. We have our basic application materials here. We have the application that was stamped in on March 25th. We have the detailed project description. We have updated plot plan. We were kind of going back and forth on stamps and what was shown. So we've got a nice plan that shows all the existing conditions as well as the proposed shed, stamped by the surveyor with the zoning table so we can see all the setbacks, coverages. The plan was very well done. The current deed, and then we have the paperwork from Reed Sherry. That's where we got the elevation from. There was no sense in going in any more detail than that. Now we get into our criteria. This lot exceeds the area for the R2 district. All other requirements are in compliance, except for that existing side yard of the principal dwelling. The additional 280 square feet will comply and exceed all of the dimensional requirements for the R2 district. As far as vehicles, traffic, convenience, none of that's really changing. The driveway opening is existing and will remain unchanged, used during construction for a brief period. Don't anticipate any additional pedestrian, bicycle, or vehicular activity as a result of the shed. Questions about parking and loading. Again, that's not really applicable. Everything is existing. We don't need any additional parking for the shed. More than enough parking on the lot and the garage. Again, looking at, you know, the structure, the colors, materials. Again, this is one of the criteria that we had taken out, colors and materials, because we really have no jurisdiction over that. The shed does does meet the required minimum setbacks. And as noted in the elevation shown earlier, very attractive standard shed. Shed will be used for storage. That was noted in the application from Mark, and no utility connections are proposed. Given the nature and use of and proximity of abutting structures on and off premise, it's highly unlikely the proposed shed will have a detrimental impact. Mark did provide some detail on the OpenGov. Thank you for that. There were some questions from the engineering department related to their stormwater authority and jurisdiction. And there will be some prepping of the area, brush, bushes, some smaller trees will be removed, and there will be one larger oak tree over 6 inches of diameter, not within the setbacks, but in the general area of the shed. The proposed shed will have no impact on natural resources, the groundwater or open space. Again, very de minimis increase in lot coverage. The shed will not impact town resources. The shed as designed and located on the property will not be incongruent or inappropriate in character, nor will the architectural appearance conflict with other structures on the property. And the shed complies with the other requirements in the zoning bylaw.
Okay.
And then, yep.
So, Jody, would you like to make the motion?
Sure. I'd like to make a motion to approve the preliminary site plan review application for the accessory shed structure and all supporting materials referenced in section 2 of the staff report dated April 2nd, 2026, with the conditions contained there within. Do you need me to read them all, or should we just say as referenced in items 1 through 7?
Yeah,
Absolutely
you don't.
right.
As referenced in items 1 through 7.
Do I hear a second?
Second,
Thank you, Val. And we'll take a vote. Val,
yes.
Jody,
Yes.
Katie,
Yes.
and Carol, yes. Okay, thank you very much.
Thank you.
Are we done?
Oh, that's
We're
it?
good?
Yes, you're good.
Right on. Thank you very
I'll
much.
reach out with some paperwork, Mark.
A lot of good guidance and help. We
Yeah,
really
thanks so
appreciate
much,
it.
Melissa. Really appreciate it.
Oh, you're welcome. My pleasure. You were one of my better applicants so far. So
Right on.
We needed a lot of hand holding, so thank you.
Yes.
Okay,
That's what we're
thank
here
you,
for.
Kathy and Mark.
Thanks very much.
Okay.
Take care, everyone.
have a good night.
Good night. Item number 2C is an update on a review of an advisory letter from Town Council for Nina Pickering Cook. This goes back to a discussion that we had on 20 Haven Street and the issues that were raised by several folks about the ownership of the property and how that might relate to site plan review and the planning board's activities. And we said at the time that we would have council providing us with information on this. This letter is important and will be included in the minutes so that anybody can see it on the website. And Melissa, can I just ask you to sort of summarize the
Yes, I highlighted. I have a version here, not highlighted on the screen, but did highlight sort of some takeaways and had an opportunity to discuss with Nina and Martel from Anderson and Krieger their findings. So, in the beginning paragraph, I love attorneys because they always summarize in one paragraph what 418 pages say. But this one was only a few pages. So, in short, when considering the use of a property, the board must only consider the proposed use, the board must only consider whether the proposed use complies with zoning among other relevant site factors. Again, quoting from the letter, in addition, who owns a property is only relevant on a procedural basis when the board is verifying that the applicant is the owner of record on the application. Permitting the use of the property does not turn on questions of ownership or personal skepticism about intended use of the property. So who are the people that have filled out the application? Who was being the applicant, maybe the property owner sometimes is somebody different, and what in fact have they submitted and are seeking from the board, and that's what our decision has to rely on, the facts of the case in front of the board. The first section of the memo, application review criteria. Kate,
Melissa, I don't think we need to go through that aspect of the memo.
Oh, I was just gonna go to one sentence. Sorry, Carol. I was
Okay.
getting there. Just that last
Okay.
sentence, where stated from the attorney, this means that the board's site plan review and analysis would remain strictly focused on the proposed structure and whether, again, the use is allowed. So going back again to the structure and use. Unlawful application and considerations. Unfortunately, somebody's reputation, who they are, whether you like them, whether you don't, whether they're new, whether they're old, whether they're irrelevant. They could be a clown, literally a clown. These issues, however, should not be factored into the board's consideration. So it's not about the who, it's about what they're asking to do. I used to have a saying and still do. It's not the people, it's the property we're reviewing. People come and go, uses stay, structures stay. Land is around forever, as we know these days. So those were some of the major takeaways. Again, we need to look at the merits of the application. We cannot project potential, what could happen down the road. When something does happen, takes us to section 3, which is where zoning violations go, and that is to the building inspector, who is our zoning enforcement agent. So that was a very high-level summary. The memo has been prepared and circulated to all the board members. Any other questions or clarification? Hopefully those can be clarified tonight. And if needed, we can circle back with town council.
Any comments from planning board members on the memo?
None, thank you.
No.
Okay. Item number 2D is just an update on the housing development study and the public forum that we held on March 31st.
Yeah. So very quickly, I know it's late. Check out our website, please. We've got 15 ways to get there from any page on the website. Thanks to Christine, again, really being helpful on the getting the word out front. The forum went well. We had good attendance. But I'm raising the bar on myself, and we can do better, and we will do better, and we're going to get more people. Please spread the word. If you didn't have a chance to make the forum, we're going to be putting the video up on the dedicated website. The website is going to be continued to be populated with different questions. Survey is going to be coming soon. So please reach out with any questions. Grab a neighbor or friend. I can't emphasize, as we did the other night, we need input, and the more input we get, the better the plan is going to be reflective of the goals and desires of Dover's residents. So if you can't make a meeting, shoot me an email, tell me what you like, what you don't like. Let's have a conversation in the office. There's multiple ways to share your opinion and really as much information as we can. Thank you.
The slides were great. I want to thank Robin for her excellent introduction at the hearing. And there was an interesting debate and interview by the 2 planning board folks that are running in Needham. And you might look for it on the Needham newsletter. But it really highlighted the fact that planning boards are here to plan and to plan for the future. And we can spend 2 hours, wordsmithing a bylaw for site plan review. But really, our really main job is to plan for the future. So housing, as we all know, is a huge issue for Dover. And I just urge you all to keep up to date on what's going on with the Housing Task Force. It's very, very important because ultimately it will be the planning board that will need to do the bylaws just to support the results of the recommendations of the task force. And Melissa, thank you for everything you did putting that together. It was great.
My pleasure.
Approval of minutes, March 23rd. They were part of the package. Any comments from anybody? Thank you,
None.
Christine, for doing the minutes. I'm going to make a motion to approve the minutes of March 23rd as submitted. Do I hear a second?
Second.
Great. All in favor, Jody,
Yes.
Katie,
Yes.
Val,
Yes.
and Carol, yes. Okay, thank you for that. Melissa, I can't imagine that you have many updates at this point, but are there any updates?
I'm going to take a pass. All things town meeting, presentations, trying to keep it all in order, trying to do a good job, trying to communicate with residents, get the word out. Yeah, and Christine and I just really working as a team. We've had a couple busy weeks. We're going to be moving offices this week next door, so be patient if you call or email and we don't follow up right away. So just lots going on. Good things though, making a lot of progress.
Yeah, the output has just been absolutely incredible. It's a wonderful, wonderful team. I have no updates other than to remind everybody that the April 13th meeting, this coming Monday, is a public hearing as well, but we have got to finalize the zoning bylaw, the site plan review bylaw at that point. So please think about tonight, take another glance, get information back to Melissa. And I think that's about it. Any other comments from the board? Okay, in that case, I'm going to make a motion to close the meeting at 9:46 p.m. Oh my goodness. Do I hear a second?
Second.
All in favor, Jody,
Yes.
Katie,
Yes.
Val,
Yes.
Hi.
and me, yes. All of
Oh,
us.
sorry, I'm not Val.
I'm sure Eric's a yes as well, right? So thank you all very much. I know it was a very, very long meeting, but it really was important to get into the weeds here because
Yes.
there are folks who are going to be getting into the weeds at town meetings, so we might as well get it done now. So thank you all very much. See you next Monday.
Thank you, everyone.
will.
Have a great night.
Right.
Thank
Thank
you.
you.
Nice
Thank
work,
you. Good night.
Melissa.